Welcome to the fourth of Keating's procurement surgeries, run entirely by volunteers whose views have been kept at an appropriate temperature in the Keating fridge and are guaranteed at least 95% effective, although we're not saying which 95%. I'm David Gollancz, and for this surgery, we're going to major on one case, Bechtel Limited and HS2 Limited, 2021 EWHC 458 in the TCC. And this is not because Sarah Hannaford QC, Simon, Taylor and Ben Graff absolutely caned the opposition and the lawyer nominated Sarah as its barrister of the week, but because it's very interesting and instructive. And the judgment runs to 150 pages. So while we're sure that you will read every word with rapt attention, we hope that today's surgery, besides offering the opportunity to ask questions about the case, will enrich the experience of reading it. Also because it's probably the only procurement case where the judge found himself referring to parties as Gorgonzola and Stilton. And you will have to read the case if you want to know why that was. As always, we will start with a short presentation by each of our panel, followed by an opportunity for you to submit questions on the topic. If you want to ask a question, please do so via the Q&A button at the bottom of your screen. And please don't get confused with the chat button, which won't post a question that's guaranteed to get seen. You can post questions anonymously if you wish. My apologies in advance to anyone who asks a question and is not answered. We are going to stick fairly rigidly to time. Before we start, please observe the Chatham House rule. You're welcome to quote anything you hear this afternoon, but please don't attribute it to any individual or organisation. And if we have time, we are going to touch on one or two other cases, but not in the sort of thoroughness and detail that we're going to look at the HS2 case. So with that, Simon, I think you're going to pull us out of the station.
Yeah, thank you, David. So what I'm going to do is give you a whistle-stop tour through the law, the statements of law, which run through the judgment. They're not all in one place. So I'm actually going to give you some paragraph references as I go along. I'm going to cover 8 topics, and so necessarily all of them very briefly. So topic number 1, nature of judicial oversight, paragraphs 18 onwards. The judge made it clear that the court's role was that of a supervisory jurisdiction. It would only interfere where there were manifest errors of assessment, and it would give suitable recognition to the institutional competence of authorities and utilities, and in particular, the expertise of their evaluators, their subject matter experts. And he said later in the judgment, there is no judicial remedy for subjective dissatisfaction with the outcome of procurement. Topic number 2, the nature of the claimant's evidence. And this is from paragraphs 136 onwards. Much of the statements were inadmissible or contained content that was inadmissible or were of only marginal relevance. And the reason for this is that much of it was the subjective opinion of Bechtel on the evaluations performed by HS2 and the appropriate score that should have been awarded in Bechtel's view to itself and also to the successful bidder. And the judge said that those sort of subjective opinions don't advance the claimant's case, because the issue is whether there were in fact manifest errors, and the documents generally speak for themselves in that regard, plus cross-examination of the defendant's witnesses. Now, the claimant's evidence could be used, for example, to explain the technicalities of their bid, but their subjective opinion on the scores didn't really take them very much further. And then in relation to the interpretation of the tender documents, the judge referred to the Healthcare at Home Supreme Court ruling and the Arwine test, the objective test of what a reasonably well-informed and normally diligent tenderer would consider the rules to mean. And again, the court said that the court does not hear evidence from a person offered up as a candidate for the Arwine tenderer. Bechtel had argued that it was a suitable proxy for that objective Arwine tenderer. The court said it rejected that argument. It's an objective test and a matter of interpretation for the court. Third, transparency and record keeping. And this is from paragraphs 274 onwards. The requirement is, and the case of Lancashire where was quoted, is to keep suitable records to enable, firstly, the economic operator to understand the reasons for decisions taken that were adverse to it, and secondly, for the court to exercise its supervisory jurisdiction. And here there were comprehensive reasons which were provided in the standstill letter in particular, which explained why Bechtel lost. There was one area where there was not a proper record, and this was in relation to the minutes of a post-tender clarification meeting, the 5th of September meeting. Now Bechtel argued that as a result of this lack of record keeping, the award decision should be set aside. But the court held that it looks to what the consequences are of the lack of record keeping. This wasn't a case like Lancashire where the records that were missing went to the evaluation itself. So this was a breach of the transparency principle in the judge's finding, but it was a technical breach. It was de minimis. In relation to the 5th of September meeting, there was an issue with resources over the successful tenderer's bid, and they scored concerns for one of the question. But the judge said it was sensible to seek clarification at that meeting. It was permitted and it was provided for in the tender rules. So this breach in terms of the record keeping had no causative effect. The court was able to glean what happened at that meeting from the oral evidence. And while the lack of record keeping may sound in cost, it didn't have any outcome on the tender, on the outcome of the case. Fourth, good administration applicable to HS2. No, there wasn't. The court said that there isn't such a duty in the regulations. The case of Thailand against the European Commission was a case against the European Commission. And there was no reason, no basis for elevating the duty of good administration to a general duty applicable to authorities or utilities. And in any event, it didn't matter because the principle doesn't add much or anything to the principles of transparency and equal treatment. Fifthly, and that was at paragraph 295 onwards. Fifthly, equal treatment. This is from paragraph 302 of the judgment. Very briefly, the court referred to the two limbs of equal treatment. Firstly, comparable situations must be treated. It must not be treated differently, and different situations must not be treated in the same way unless, second limb, the treatment is objectively justifiable. And the judge followed the Supreme Court in the Rotherham case, in which the argument that the margin of discretion only applies to the question of objective justification, that was rejected in Rotherham and rejected by Mr. Justice Fraser. And he quoted, again from the Stagecoach case, what is forbidden is unequal treatment which falls outside the margin of discretion. So it's not a hard-edged principle. There is a margin of discretion. Sixth, proportionality. And this is paragraphs 311 onwards. The judge found that there are sensible limits of what an authority or a utility is required to do in the course of a procurement in relation, for example, to its record-keeping duties. And this is as a result of the principle of proportionality. It's a principle which limits the procedural burdens that are applicable to authorities and utilities. And the judge quoted from Arrowsmith on this. In this case, in the case of HS2, the evaluators have been given training based on Mr. Justice Fraser's own ruling in the NDA case. But he said there was no reason to go further to protect itself to the nth degree in for example, recording the minutes of moderation meetings, because that would impose a burden which would not be proportionate. Seventh, abnormally low tenders. This is paragraph 463 onwards. The judge summarised his own judgment from SRCL against NHS England. So, for example, there was only a limited duty to investigate where the authority had found that there was an abnormally low tender, and no duty to reject if there was an abnormally low tender, just a power. But whereas here, the authority or utility does investigate whether or not the tender is abnormally low, the court will, as Mr. Justice Fraser did, consider the steps taken by the utility, and in particular, whether there was any manifest error in those steps, whether there was any irrationality. And he concluded that there were no errors. If there had been a manifest error, then he would have put his mind to the hypothetical question of whether they would then have rejected the tender. But there weren't any errors, so he didn't need to do that. What actually happened was that HS2, as they were entitled to do under the Impresa Lombardini case law, they set an anomaly threshold, which was by reference to the contract awarded and the way in which it was assessed. And this was a fee collar, so that if the fee percentage didn't go below the fee collar, then it was considered a sustainable bid. And HS2 also made a comparative assessment of staff rates. So the court rejected the Bechtel argument that the resources problem meant that it was an abnormally low tender because the level of resources wasn't part of the price or cost assessment, and the anomaly threshold chosen was a lawful one. And then lastly, point 8, material change, which is the next last bit of the judgment. There was an argument that there were changes made both to the contract and to the resource schedule in particular of the successful bidder at the preferred bidder stage, and that this was impermissible, and that as a result, Bechtel argued that the tender should have been re-invited. There were certain project delays as a result of there were certain project changes as a result of the delay in significant part between the date when tenders were invited and the date when the suspension was lifted and the contract was entered into, and the successful bidder did change its resource levels partly to adapt to those project changes. But the judge accepted the submission again that there is flexibility in the negotiated procedure under the utilities regulations, and more so than under the public contract regulations. He referred again to Arrowsmith and the London Underground case, which was a European Commission decision in relation to state aid matters where there were very significant, in the context of a utilities regulations case, very significant post-tender negotiations. And he concluded, not because that was a precedent binding on him, but because he agreed that in this case, on the basis of the regulations, there was a similar flexibility, and that the flexibility was also built into the tender rules. So that is my whistle-stop tour of the law, and I'm now going to hand over to Sarah to make sense of the facts.
Hi, thanks very much, Simon. Right, I'm going to do a whistle-stop tour of some of the facts. So I wanted to look very briefly at the claims made by Bechtel and the impact of the judgment on, first of all, the prospects of success of future challenges, and secondly, how to run future challenges in the light, run and defend future challenges in the light of the judgment. So the claims made by Bechtel, almost all of Bechtel's claims sprang from the evaluation of one question, which was number E001, and it was about resourcing. And one evaluator had originally given BBVS, the winning bidder, a score of major concerns for that question. At the consensus meeting, though, the two evaluators agreed on a score of concerns. Major concerns would have meant the possibility of discretionary exclusion from the competition. Concerns didn't. Now, arising from that, Bechtel said a number of things. First of all, it said that the score for E001, so that was the resource in question, should have been major concerns, in line with what one of the evaluators had initially said, and not the higher score of concerns. Secondly, Bechtel went on to argue that the level of resources, the low level of resources, which could be seen from E001, should have impacted on BBVS's score for a number of other technical questions. And thirdly, they argued that the level of resources meant the tender should have been excluded for being abnormally low because there weren't enough resources, and therefore the price must be abnormally low. Bechtel also challenged a number of other technical evaluations, generally arguing that the consensus scores for BBVS were too high, and in some cases that the scores that they should have been awarded should have been the same as the scores for BBVS or higher than that. So those are the claims awarded, the claims run, and as I say, they mainly sprang from this point about resourcing. A number of interesting points arise from the judgment in relation to those issues. The first, I think, is the question of the status of individual scores. The judge made it very clear that the evaluators' original individual scores were just draft scores or initial scores or provisional scores. They weren't the actual scores. And in this procurement, that is what the ITT said in terms. It referred to them as draft scores. But the judge didn't just rely on that in saying that the individual scores were just provisional starting points. He considered that the score that you have to challenge as a losing bidder is the final score, not the individual score. And he also thought, as Simon has indicated, that it wasn't any good for a claimant to rely on its own subjective view that one of the individual evaluators was right and the other was wrong. It had to, in fact, prove a manifest error at the consensus or moderation stage. So that's the status of individual scores. They don't have a great status. What you need to challenge as a challenger is the final scores. The second interesting point to take from the judgment on the facts, I think, is that the judge accepted that it wasn't a counsel of perfection. There was no need for a procurement to be a counsel of perfection. We all know, I think, that it isn't possible to run a huge procurement perfectly. There will always be some things that go wrong, some things that escape people's attention. And what is very useful about this case, I think, is its clear judicial recognition of that fact. And as Simon has said, the judge recognised that there was one meeting where he didn't think adequate notes were taken, but it was a de minimis breach of the obligation of transparency. So a contracting authority, I think, is in the clear if it hasn't made any manifest errors, and manifest errors are not demonstrated simply by a claimant expressing a preference for the view of one of the evaluators. So not a counsel of perfection. The third point of interest, I think, is that where an authority has set up a clear evaluation scheme, there isn't room to argue that a problem which has emerged from the outcome to one question should affect lots of other scores. So here, the resources and the adequacy of the resources were considered not in relation to each part of the works, but in one separate lump, in one question, which was E001. And what Bechtel wanted to argue was that low resources in each area of the bid should be taken into account in evaluating each separate area of the bid, as well as in the resources question. But the judge said no to that because that wasn't the way the procurement had been set up. The procurement had been set up so that resources were evaluated all at once, together in one question, E001. So they couldn't, the low score given to the winning bidder in relation to E001 couldn't infect the other scores. And similarly, for the allegation about there being an abnormally low tender, the ITT, as Simon explained, fixed an anomaly threshold for fees of a particular percentage that you couldn't go below. And questions about the amount of resources were separately dealt with in question E001 and shouldn't be dealt with again when you're looking at abnormally low tenders, because the low resources were reflected in the score for E001. And the fourth point, I think, that is interesting from the judgment is that the judge does make it clear, and again, Simon's touched on this in his analysis of the law, he makes it clear that there isn't a bar on having a meeting with the winning tenderer after the evaluation in order to clarify. Obviously, we all know you've got to be careful, but you shouldn't not do it if you feel you need to clarify something. In this case, the ITT expressly permitted it, and that obviously is a very important start. Unfortunately, as the judgment makes clear, the minutes weren't detailed enough, but the judge thought that where there had been a score of concerns for resourcing, and therefore concerns existed in relation to resourcing, it was perfectly proper for the authority to have a meeting to clarify the level of resources. And that, he pointed out, resulted in one rather helpful clarification, which was where the authority thought that Bechtel were, BBVS were showing 175% utilisation of some resources, and that could be clarified quite easily by way of this meeting. So those are some of the key takeaways on the facts. What can we learn for the future from the judgment? I've come up with 5 points. First of all, and some of them Simon's touched on in relation to the law. First of all, the claimant's evidence. The judge made it quite clear that a claimant's witnesses don't need to provide a commentary on the scores and the reasons why the scores are wrong, either too low for them or too high for the winning bidder. That's either inadmissible or irrelevant. And if the claimant does do that and you're acting for the defendant, the judge made it quite clear that you don't need to bother to challenge all of that evidence in cross-examination. So it's clear, and helpfully so, that the claimant doesn't need to spend too much time and effort in putting in evidence on why the scores are wrong. That's the matter that you have to deal with as a claimant by way of cross-examination of the defendant's witnesses. Second point, and a question I've been asked a few times since this judgment, can a claimant ever win a scoring challenge now? Is it now all too difficult? The answer to that question, in my view, is yes, a claimant can win, but don't place too much reliance on the initial scores. They may be useful for cross-examination, but they in themselves don't help you prove that the final scores for questions were manifestly wrong. Also, it's likely to be difficult to persuade a judge to change a score if the score you're arguing for is a 4 and the winning bidder was awarded a 5, or is a 0 and the winning bidder was awarded a 1. If you're just changing by 1 increment, it's going to be quite difficult because the judge there is likely to take into account the margin of discretion and the expertise of the evaluators, and is unlikely to change scores by that amount. I'm not saying it won't happen, but unlikely, I think we can take away from this judgment. But if, as in the Milton Keynes decision, the authority awarded full marks when they should have awarded 0 because they hadn't properly read their own mark scheme, which said that if you didn't deal with the whole question, you could only get a 0, then of course there's still plenty of room for showing a manifest error. So I think the answer from a contracting authority's point of view now to scoring challenges is to make sure that you follow a proper process, make sure that your proper process is properly documented, and make sure that the evaluators have read and understood the tenders and read and understood the marking scheme, so there can't be any allegation of material manifest error. What does a challenger need to do? Well, you need, as a challenger, I think, to find more than a disagreement at the initial stage between evaluators and a preference for one evaluator's view at the initial stage. What you need to be looking for is the reverse of what I've just said. So you need to be looking to find a failure to apply the mark scheme, a failure to read the tenders properly, or a clear mistake in the consensus rationale. The third point, takeaway point for future procurements, again, I've been asked this quite a bit. Has Fraser, Mr. Justice Fraser, now rowed back on his findings in NDA? I think the answer to that is no. The law is still the same. He's clarified the position on the margin of discretion in relation to equal treatment, but the law is still the same. The facts, however, were very different. In NDA, there were some clear manifest errors, and there also were not, at least not giving evidence, I think, enough evaluators or enough witnesses. And that brings me on to my fourth takeaway point, which is how to deal with the defendant's evidence, because I think there is a fairly stark contrast between the approach taken by the defendants in the HS2 case and in the NDA case. In the NDA case, the judge criticised NDA for putting too much weight on one witness. not only was he under huge pressure, the judge found, as an evaluator, but he also was as a witness. In HS2, and the judge in NDA said that may well be why mistakes were made. In HS2, in contrast, the defendant called a witness in relation to each question, as well as some witnesses on the governance process. And I suggest in future, the correct approach is to make sure you don't make one evaluator evaluate too many questions, and also don't put too many eggs in one basket when you call your witnesses. You need to make sure you call a witness who can deal from his or her own personal knowledge with the evaluation of each question. And then my final takeaway point for the future, record keeping. It's obviously very important to document the process. Regulation 84 says you have to keep documents to justify all the decisions made. Surprising how often that doesn't happen. What do you need to keep records of? Obviously the evaluation, but thinking about that, what do you have to keep records of? Is it the reasons for the change from the initial score to the consensus score, or is it the reasons for the consensus score? And I would say what's clear from the judgment in NDA is it's the reasons for the consensus score that need to be clearly documented. The reasons for the change were attacked, or the alleged lack of reasons for the change were attacked by Bechtel in the case. But in fact, the judge didn't go for that approach. What you need to make sure you've got recorded is your reasons for your actual final score. Obviously, insofar as possible, you also need to keep notes of all meetings, but the lack of minutes for one meeting is unlikely to pull the procurement down. So obviously, as full records as you possibly can keep if you're the authority, because any challenger will be looking for holes in your records. But provided you have got proper reasons for your consensus scores, you've got a proper record of the decisions you made, and you've got proper records insofar as you can for all the meetings at which important issues were discussed, you should be in the clear. And I'll leave it there and pass over to Ben.
Thank you, Sarah. I'm going to discuss two discrete issues. Firstly, the court's judgment on the issue of Bechtel's qualification, and secondly, the court's treatment of the interested party's application for its costs. Now, perhaps the most important point on the facts was whether Bechtel would have been disqualified from the procurement if it had been the winning bidder. HS2 said that irrespective of Bechtel's claims regarding the alleged breaches of the regulations, Bechtel could not establish that it suffered any loss because if it had been ranked first, it would have been disqualified for failing to withdraw a fundamental qualification to its bid. Bechtel said that this argument was not available to HS2, as the ITT provided a mechanism for disqualifying bidders on the basis of their qualifications, and this process had not been followed to its conclusion. In particular, the ITT said that HS2 would issue a withdrawal ultimatum, alerting the bidder to the fact that it would be disqualified if the qualification was not withdrawn, and HS2 had not issued such an ultimatum. Bechtel argued further that on the balance of probabilities, in the event that Bechtel had been ranked first, it would have met with HS2 and the parties would have agreed a mutually agreeable solution, or at the very least, there was a chance that this would have happened. The court agreed with HS2 and found that Bechtel would have been disqualified. Firstly, the court considered the qualification to be fundamental. It had the effect of entirely shifting the financial risk profile of the contract from the construction partner to HS2. And it was found to be directly contradictory to the commercial rationale of the procurement. Secondly, on the evidence, the court found HS2 would not have accepted the qualification and Bechtel would not have withdrawn it. The evidence in this regard was reasonably stark. HS2 had asked Bechtel to withdraw its qualification 3 times and Bechtel had refused each time. HS2 had maintained throughout both the procurement and the trial that it could not accept the qualification. Further, Bechtel did not adduce any evidence suggesting that it would have withdrawn the qualification. Thirdly, the issuing of a withdrawal ultimatum was not a condition precedent to HS2 exercising its right to disqualify. As such, its decision not to issue an ultimatum was immaterial. The court said that on this finding on qualifications alone, the claim failed. Mr. Justice Fraser also noted in passing that due to the significance of the qualification, if HS2 had accepted it to that tendered, that this would have arguably constituted a breach of the principle of equal treatment, and perhaps would have entitled the other bidders to challenge this decision. Now, the points to take from this are the following. From the bidder's perspective, one should be wary of A, submitting a bid with a qualification that could be deemed to be significant, and B, from issuing a challenge where a significant qualification remained outstanding on its bid. It is possible that, as in this case, the failure to withdraw such a qualification could be fatal to a challenge, irrespective of the merits of the other aspects of the bidder's case. From a contracting authority's perspective, care should be exercised when accepting qualifications. If the qualification proposed significantly alters the contract tendered, then accepting it could constitute a breach of equal treatment. There's one further point to mention on this, which is that there was a question that was raised in the judgment as to whether the qualifications issue should have been dealt with by way of a preliminary issue. The first point to note is that it would have entirely disposed of the claim. Therefore, this kind of issue, in which the contracting authority alleges that the bidder would have been disqualified, may in principle be appropriate for a preliminary issue. However, even as in this case, where the evidence all seems to point in one direction, this may not be evident until it unfolds at trial. In addition, the court commented, as it has elsewhere, that preliminary issues can sometimes not be the attractive shortcuts that they initially appear to be. The issue may be more tangled up with other relevant matters or require more of an in-depth analysis of the facts than initially appeared to be the case. I'm now going to consider an important point that was raised after the conclusion of the liability trial, which is whether, following the defeat of the challenge to the procurement, the winning bidder, BBVS, could recover its costs incurred in relation to the litigation from the unsuccessful claimant, Bechtel. The court explained that this was a point of important and wider interest, and was an issue on which there was very little authority. Mr. Justice Fraser applied the decision of the House of Lords in Bolton MDC and Secretary of State for the Environment, which was a planning matter, in which a developer was awarded its costs incurred in acting as an interested party. From this decision, the court derived 6 principles that it considered to be of general application to costs applications by interested parties in procurement challenges. So first, the court has a discretion to award costs, and that will be exercised in accordance with CPR Part 44. Second, the interested party must be able to show that there is a separate issue on which it is entitled to be heard, i.e. some matter in which its interests and the interests of the contracting authority are not entirely aligned. Third, the mere fact that a party has won the bid does not automatically entitle it to either become an interested party or to recover its costs in the event that the challenge fails. Fourth, the court will, when granting the winning bidder the status of interested party, have made an order in this respect, and that order will govern the extent to which the interested party is entitled to participate in proceedings. That is a prerequisite to any recovery of costs. Fifth, that said, the order will not of itself entitle the interested party to recover its costs. And sixth, there may be specific and unusual features of the case that will make an award of costs more likely. Mr. Justice Fraser made it clear that the court will not provide an exhaustive list of the kinds of facts that will fall into this category. The only thing left to say is that in this case, the court held that a number of specific and unusual features applied that will not be present in most procurement challenges. The scale of the project was of an exceptional size. The contract was to last 8 years and had a value of over £1 billion. The project was extremely high profile, and there would have been a significant reputational impact on BBVS if the challenge had been successful. In addition, a significant element of the challenge was the allegation that BBVS's tender was abnormally low. This required detailed analysis of the fee submitted by BBVS and its profit percentage, which was confidential information of the most commercially sensitive type. This confidential information could, in the court's view, have been potentially relevant to a future BBVS bid for a subsequent procurement run by HS2. As a result of all of these matters, BBVS had a sufficiently independent interest in protecting its confidential information that justified separate representation, and as such, it was entitled to recover these costs from Bechtel. The court's award was limited to these costs, i.e. those incurred in protecting confidential information, as this was the extent of BBVS's participation that was permitted in the order adding it as an interested party to the proceedings. So, to sum up, this judgment demonstrates that an interested party can successfully recover its costs from an unsuccessful claimant. But as the court's award was based on the unusual features of this particular challenge, the decision should not be considered to be authority for the proposition that such applications will generally be determined in favour of the winning bidder. Now back to David.
Thank you, Ben. Thank you, Simon, and thank you, Sarah. That was lucid and riveting. We have questions, but I'm going to abuse my position to ask one of my own, which is this. Simon, you helpfully gave paragraph references, and I'm going to do the same. Paragraph 302, the judge enters quite a sort of detailed and penetrating discussion of equal treatment and the rules around equal treatment. I think following but perhaps expanding, Sarah, your case of Ryehurst, am I right? Finds that there is what he at one point calls a margin of discretion and at another point calls a margin of judgment. And I'll come in a second to comment on that, but as to the obligation of equal treatment. And it reads to me as though we've got to a point where the formulation of Mr. Justice Morgan in Lion Apparel and Firebuy Limited, which is now quite an old case in procurement terms, where he did seem to say that there was no margin when it came to equal treatment and transparency. These were absolute, hard-edged, to use the contemporary jargon, obligations. But we've now reached a point where there is some sort of margin of something. And I just wondered if you'd like to expand on that at all, because it seemed to me quite a significant development.
Would you like me to do that?
Yes, well, yes. Like anyone.
Sure. Absolutely. And then Sarah and Ben, feel free to add to me to what I say. No, I think the judge made it clear that he didn't disagree with the judgment in Lion v. Firebuy. Or am I imagining that? Perhaps it's something he said during the hearing. But I think that the reality is that when you look at the nitty gritty of where breach of equal treatment applies, in this case, it was effectively an allegation that the two bids had been the criteria had been applied differently to the two bids, such that the scores were wrong. It was almost indistinguishable from a manifest error claim. So that's the first point. It's very difficult to say that there's discretion with manifest error and not with breach of equal treatment. But my second point would be, when you look at the two limbs of equal treatment, the question of whether there's an objective justification, obviously that there has to be discretion in determining what is objectively justified and what isn't, because clearly that is a judgment. And in relation to the first limb, the question of what is a comparator, what is a comparative situation, then that is such a fact-specific exercise as well. So to me, it's entirely logical that there is a judgment involved at every step in procurement claims of applying that principle.
Sarah, do you want to add anything to that?
Well, I think that's right. I think we all proceeded on a false premise from Lion and Firebuy onwards. But all I would add is obviously that's right, that there is judgment at those stages. But I don't think anyone should run away with the thought that authorities can now decide whether or not they fancy treating bidders equally. It's not that sort of level of judgment.
Good. I'm very relieved. But I'm not going to forbear to also make this comment, which may strike some as a little pedantic, but I think is important, which is that there's actually a big difference between judgment and discretion. And the exercise of judgment as to facts clearly can only be vitiated by a manifest error. The exercise of a discretion has always seemed to me to be something rather different. So, for example, the admin court has a discretion as to whether to grant a remedy, even if it has judged that the public defendant has breached its obligations. But unless anybody wants to have a fight with me about that, I'll just let that one hang. I do think we need to distinguish between judgment and discretion. Anyone want to fight about that? No? Oh, well, never mind. We have one other question, though, about manifest error. I mean, this is I think, just an understandable attempt to just really sort of crystallize out what the judge's comments mean, and indeed what the whole sort of line of cases means. I mean, essentially, we're in a funnily way, we're back to judgment. If there is a question which admits of the exercise of judgment or requires the exercise of judgment, is it absent completely flagrantly bonkers exercise of that judgment, pretty much impossible to challenge it. That's to say something that I think, presumably something like an evaluation. If there's a fact that's wrong, like an arithmetical error, for example, or as in Woods and Milton Keynes, Sarah, to which you referred, where there's a flagrant failure to follow the marking scheme, that's going to be challengeable. But where you're trying to say, yeah, they got that wrong, it should have been a 3 rather than a 4 or whatever, as you say, that it's just not going to fly, is it? I mean,
I think that's not going to fly.
Right.
That was the point I was trying to make earlier. I think if you're looking at the difference between a 3 and a 4, for example, you're not on good ground as a claimant. You need to have something that you can grab onto and call a manifest error, which is going to be the difference between a 5 and a 2 or a 5 and a 0, or, as you say, an obviously wrong fact. Or if two bids, I mean, again, this happened in Milton Keynes, there are 2 bids, one scores higher than the other, but the judge looking at them said it was pretty clear that the one that scored higher was at a very high level of generality in answer to one of the questions, and the other one had some real detail. And if you're looking at equal treatment, they've obviously got it the wrong way round. Again, that's going to be an obvious manifest error, isn't it? But it's going to have to be pretty obvious.
Yeah.
But I think that was always the case.
Yes. But we have moved on, though, I think, from at least from the common understanding of line apparel, haven't we?
Oh, yes.
So, and we're going to move on now also with questions, because we have 3 about other cases. Hooray. There's one about Bromcom, which I am aware of. I take that to be something between a bromance and a rom-com. I'm not sure. But this was, I think, the case where there was a heated exchange of views, wasn't there, in over Zoom. And I think, Sarah, you volunteered to deal with this. The question is, how important is the context and circumstances of the way information is provided to whether the 30-day period, the limitation period, is triggered?
Yeah, it's quite an interesting question, this, because you have such a short limitation period in procurement cases. And how do you know as a claimant whether you have sufficient information to start a claim? We're all terribly cautious about that and assume we have sufficient information straight away. And you only run arguments, as in cases like Bromcom, usually, if you have to. But in that case, the original feedback letter was said by the judge to be inadequate, sketchy and inadequate, he called it. It was withdrawn and a new letter was subsequently provided. And there were some, as you say, exchanges on, I think it was Teams rather than Zoom, one of which resulted in a rather heated session, according to the judge. And he said all of that, the context of all of that meant that the information wasn't clear enough and time didn't start to run until I think the revised standstill letter was issued. I think that's quite interesting and quite a helpful development for claimants. On the other hand, I think you've got to be a fairly brave claimant to say to yourself, well, I've got a slightly sketchy standstill letter, and I've just had a bit of a row with them on Teams, so I'm going to assume time doesn't start running. I think we'll all still assume time starts running. But if need be, you've got Bromcom up your sleeve.
I think that must be the 95% effective advice, yes, or view. Sorry, of course, it's not advice. Nothing we say here is advice. Yeah, and we also have this is also about costs. How are costs determined after settlement of an automatic suspension application? And I think, Simon, you volunteered to deal with this with reference to 2 cases, accessible orthodontics and Aquila, is that right?
Yeah, Aquila, Hayward and Local Pension Partnership Administration is the one in particular in relation to settlement of an application to lift. But there's another one which is accessible orthodontics against NHS England, which is in relation also to settlement, but that's following the abandonment of a tender. Both in fact relate to the abandonment of a decision. Because so in Aquila, firstly, this was a case where there was decision 1 was challenged. The authority then rescored and took decision 2. Now the same bit of 1, but it was following a rescore. But the challenge related to the first decision, which was superseded by the second decision. And the issue following, there was an application to lift and there was correspondence and there was discontinuance of the first claim. And the issue was who should pay for the costs of the application to lift. And the court found that the application was unnecessary in relation to the challenge to the first decision because the first decision had been superseded by the second decision. So at that point, the suspension no longer was in force, and therefore the application was unnecessary, and therefore the claim was successful. Was a successful party for the purpose of costs. They didn't get all their costs because for some reason the claimant had been arguing that the second decision was subject to the suspension on the first decision, which is obviously a bit sort of contrary to their main case. So they got, I think, half their costs. But the other case, which is accessible orthodontics against NHS England, again earlier this year. This was a case where it was for dental services, and it was the tender award following a challenge, some 2 years after a challenge had been brought, in fact, was abandoned as a result of the COVID pandemic, because that completely changed NHS England's needs assessment of what they required for the contract. And the issue then arose as to who should pay for the quite substantial costs up to the point of the abandonment of the proceedings. And you'd probably be familiar with the M against Underborough Croydon test in relation to settlements, where the sort of settlement is categorized by reference to whether or not the claimant got what it was after. And if it got what it was after, then it should recover its costs. But in this case, the judge accepted the argument that this wasn't like that, because it wasn't a settlement, because this resulted from an abandonment which was caused by COVID, not by the litigation. And B, you couldn't fit it into a MV Croydon category, because although the claimants actually got what they were after, which was the set aside of the procedure and the retender, that was the relief they were actually seeking. What you have to do in those circumstances is that you look at what caused the abandonment. So there was a causation test, which you don't find in the MV Croydon, but you do find in certain other cases relating to immigration and housing. There's a causation case and question, and the court will look at whether the abandonment was caused by the litigation or by extraneous circumstances. And if the court's satisfied that, as here, that it was caused by something else, then there's no order as to costs unless it's tolerably clear that one side or other would have won. So the court in this case would then heard submissions from, I was acting for NHS England, from both parties that each side would have won. And in the end decided the neither side would have won necessarily. So there was no order for costs, which was the main order.
It's sort of the opposite of Alice in Wonderland, isn't it? All have won and all must have prizes. Actually, you've all lost and nobody gets anything. Great. Well, that's justice for you. That's interesting. Thank you, Simon. And we have one more question, which on whose altar I am to be sacrificed, it appears. And the question is this: can representative or campaigning bodies bring claims under the regulations? And then in brackets, it says Good Law Project, Law Society, Unison. I think the first thing I'm going to say is, if you haven't already, perhaps have a listen to the podcast recorded by Charlie Banner QC and me on the question of standing for non-economic operators with special reference to or in the light of the recent Good Law Project judgment. It's too complex and long a question to go into in detail here, but my own view is this, that the Chandler test, which oddly was obiter but is still kind of treated as determinative in subsequent judgments, has two limbs. One is whether the claimant has a sufficient interest, which effectively means that they are directly impacted by whether or not the defendant authority has complied with public procurement rules. So Mrs. Chandler couldn't succeed. She didn't have standing because it didn't really make any difference to her whether or not the provider of an academy in the London Borough of Camden was selected by a procurement rules compliant process or not. She just didn't want an academy to be provided at all. And as Mr. Justice Chamberlain said Mr. Justice Dove said in a case whose name momentarily escapes me, this is not a matter of motivation, it's a matter of relevance. Is the claimant's complaint founded in the requirements of the regulations, or is it, as it were, extraneous? And the other limb, the other basis on which somebody could succeed would be the gravity of the breach alleged. And in what looks at initially like a slightly sort of paradoxical pair of statements in Lady Justice Arden's judgment of the Court of Appeal in Chandler, she says this is not to do with the importance of the issue. It would, she says, drive a coach and horses through the requirement of standing if simply the importance of the issue conferred standing. It's the gravity of the breach or alleged breach, which of course is a different thing. You can have a very important issue, but a comparatively trivial breach, or vice versa. And that has become the sort of model which the judges try to follow. In Unison, the trade union failed the test because it was said that they didn't have sufficient interest in the way contracts were outsourced by primary care trusts, that their interest was in ensuring that they weren't outsourced. In the Law Society case, it was held that the Law Society, as the representative body of solicitors, did have sufficient interest in the way legal aid contracts were awarded, precisely because it represented solicitors whose livings were dependent on that being done properly. And most recently in Good Law Project, it was held that the Good Law Project was broadly in the same sort of position as the Law Society had been. Admittedly, it wasn't representative of a consortium of economic operators bidding for protective personal equipment contracts, but it was, as it were, bringing the action on behalf of a whole group of concerned bodies and citizens. And I think if anyone's interested in sort of looking at the root of all this reasoning, you can go back to World Development Movement and the Secretary of State, often called the Pergau Dam case, which was a case where, although I don't think the court used this language in that case, essentially it was the gravity of the breach which conferred standing on a campaigning organization which was trying to prevent the misuse of international aid monies. So I think the answer is yes. Representative and campaigning bodies can have standing to bring claims for breach of the regulations, provided that they can show sufficient interest in compliance with the regulations, or, and this is more commonly going to be the case, if they are bringing an action alleging a really grave breach, which has some genuine wide public importance. And that latter limb is more likely, I think, in the case of campaigning or representative bodies, to be the one that applies. So I hope that made some sort of sense. We've come to the end of our questions. Does any of the panel feel like chipping in on anything we've talked about? We've got a few minutes, a very few. Resounding silence. Simon, you're on mute.
Yeah, I don't know, see what you think of this, David, but given that the regulations have a standing test, which is that you need to be an economic operator, and you need to have suffered or risk suffering loss. How do you square that with the European directive and the regulations, which create private law rights? How do you square that with the ability to invoke that regulation if you don't satisfy the tests set out in the regulation for standing?
It's a good question. I think the only sort of answer with any authority is again from Chandler, where the court simply said that the regulations impose statutory obligations on public authorities, and a breach of those public law obligations is, as it were, prima facie. I think it used the phrase a paradigm situation in which judicial review should be available. And I think there is one very, very important reason why I would argue, and this is just a personal view, that it should be possible. And it's one that emerges actually from the Good Law Project cases, which is where you have a bunch of economic operators who might very well have standing and might be absolutely furious, but are not going to bring a claim because they don't want to bite the hand that they hope will feed them in the future. The fact that economic operators are in the market, I'm sure all of us has had the experience of a client who we have advised has a reasonable case, but who then decides eventually after some thought that they don't want to risk ruining their relationship with the contracting authority. And so you do get situations, I think, where there may be egregious breaches of significant public importance, but where no economic operator is willing to take the risk. And that's always the problem, isn't it, with private law enforcement of public law obligations?
Well, that sort of makes me think of the other area where there's a bit of an overlap between private and public law, which is where you've got a claimant who does have rights under the regulations who also brings a JR on essentially the same subject matter. And although there are some cases which are fairly clear that you've got an alternative remedy under the regulations and therefore you shouldn't be entitled to bring a JR, there are also other cases, notably a couple in relation to the Legal Services Commission, as it was Legal Aid Agency now, where the admin court has said, oh, well, your alternative remedy doesn't give you such good remedies as the admin court. So, I mean, that's another area where I think a bit more thinking could go on, because it does seem to me to be mad if you've got a remedy under the regulations that you should also be entitled to bring a claim for judicial review if you want a slightly better remedy, or possibly, although this shouldn't really happen if you're out of time. It shouldn't. When I say it shouldn't happen if you're out of time, that's because the CPR now says that for claims in relation to decisions under the public contract regulations, in JR you get the same time limit as you do under the regulations. Somewhat bizarrely, the CPR, despite I think you, David, having written to the editors some years ago, doesn't actually say the same in relation to the other regulations, the utilities regulations and so on. I think I'm right in saying you wrote to them, aren't I?
I've written to the editor. What? Yes, fair enough. We have an observation rather than a question from Jat Sekon. I hope I've pronounced that rightly. Whilst not having read the Good Law judgment, I take it the second in that David mentioned will have quite a high threshold to have standing, the gravity of the breach. Yeah, I think that's absolutely right. I think it needs to be something. And of course, that will be a case where the court has a significant margin of appreciation or discretion or judgment or something lovely. Anyway, it's 6 o'clock and I would love to go on because I love all this stuff and I think it's all been fascinating. Thank you, Sarah. Thank you, Simon. Thank you, Ben, for your lucid exposition of your triumph and of other cases. Thank you all whom I sadly can't see for being here and listening. Let me just again remind you that we are now doing podcasts about public procurement, which are available either on our website or on Spotify and probably other podcast platforms. So if you're really spotty and enjoy listening to other people being really spotty, that's the place to go. Thank you all for attending, and have a lovely evening.